So, pagpa-function sa kuan. So, makes your work easy or easier.
We also like to know what is the coverage of the CA Visayas station. And siguro, Attorney Lucille, during
Practically all cases coming from the Visayas, courts and quasi-judicial bodies.
are covered.
Yes, all over Visayas.
And as of today, what is the total case na
Caseload na mo karon is approximately 3,900. About 800 of them would be submitted for decision cases. Cases already ripe for decision. The rest, like 3,000 plus, would be cases in the completion stage. Completion stage meaning kanang napa sa mag-file og appellant's brief, appellee's brief, reply brief, and but prior to that, completion of the records of the case, like na mga lacking mga transcript of stenographic notes, na mga lacking exhibits, mga notice o mga minutes of hearing. Kay in many cases man gud ang ipang submit diri sa amua na ay mga kulang. So we cannot proceed with a notice to file the appellant's brief in the case of civil and criminal cases until the records
are complete?
with us are complete.
During the break march, we were talking ba nga when they started, there was about
10,000.
10,000
Yes.
cases, and now it
Grabe na trim down yun.
trimmed down to about 3,000 na lang.
900.
3,900. So in terms of disposing the cases, how does the Cebu station rank us against the Mindanao station and the one in Manila?
So,
Ang feedback lang is mas I don't know if it's true, but kusog kuno gyud ang Cebu.
in terms of kuan, proportion ba sa
Yeah, because
number of cases filed per month ug number of cases disposed per
because
month?
we average the number of cases filed per month mo average mi og mga 100 140 140 cases. Ang among disposal ana would be around 180 170. So it's more than the number of cases filed. Only nga dili lang gid na kanang tanan nga nga file di man gud na ba decide and dayon. So somehow ma-accumulate gid gihapon na siya through time kay napa may completion stage.
Actually, na period to decide. Once a case is submitted for decision, the court has only 1 year to decide that particular case. Unlike the Supreme Court nga 2 years ang ila, while RTCs they have only 60 days. I think
shorter.
Shorter, no. So mo na nga if you look at the statistical data, very encouraging kayo kay it will show you nga except for 3 years, no, 2004, 2011, 2012, ang percentage of cases disposed consistent nga over 50% of the number of cases already submitted for decision. Now, when you talk about disposal of cases, you are not talking only about deciding or decisions. No, you're talking also about resolutions like granting a motion to dismiss or dismissing an appeal because wala mo follow sa rules or prescribed na ang period to appeal, no? So the appeal na to sa atong statistics pag determine sa total number of disposed cases kana nga aspeto. So dili lang na ang decided cases kundi ang appeal na ang
Mga resolutions.
Mga in-between yung processes.
Oo.
Na-discuss ganiha ba nga usahay madugay ang pag-resolve or pag-decide sa case kay kuwang ang records and namoy ganahan mahatag tips sa atong mga viewers, especially maybe natay lawyers nagtan-aw din para mas guided sila and sa mga processes sa CA.
Actually, ang among concern gyud ani is kanang mga trial court, kanang mga branch clerk of court. Kay they're the ones who prepare the records for transmittal to the Court of Appeals. And it's in the rules mong gudunta nga before they transmit the records to us, to the Court of Appeals, dapat complete na siya. In many cases, siguro I talk
More
with
than half,
more,
dili sa
a little more than half
Oh.
of the cases elevated to the court, especially civil and criminal cases, are incomplete. Incomplete meaning kulang ang mga TSN, transcript of stenographic notes, na ay mga missing exhibits, and then na sila yung mga orders nga wala sa record, like kanang mga order giving due course to the appeal, wala na siya. So, ang himuna mo ana is we notify them na pod to complete, so to submit. Doon na usay mga transcript of stenographic notes nga walay signature sa stenographer. So burag ma-question ang authenticity kay no signature man.
That's true.
Oh, so ang himo na pud ana is we notify those personnel involved sa RTC para ma-correct nila, and that will take time because ang atong communication is through mail, manggod, registered mail. So
Snail mail.
Snail mail. And then, although there are times kap nga na mo, kuha na lang we go the extra mile, we call ahead and to inform them nga naamoy mga kulang, so makaprepare sila. And then, so kana lang, if more than 50% of the cases ingon ana, madugay jud ta.
I just would like to point out nga kana, that is the responsibility actually of the branch clerks of court. And mona di man gud ta maka go through the process of completion, which means submission of the appellant's brief, submission of the appellee's brief kung dili kompleto ang record. So kung dili kompleto ang record, dili gyud makadagan ang kaso.
That's
in order
true.
to complete the records. And only if the records are complete nga we can consider the case submitted for decision. And we have 1 year to
From that time.
decide. Oh, so mo na kung pananglitan why transcript niya usahay naka-retire na to stenographer nga nag saan man na sana na mo pagkuan.
And it's a common occurrence also nga kana mga stenographic notes nga missing. Once we notify the court concerned, wala na ang stenographer. So na-retire na or na-abroad or whatever. So dili na siya. And then the party concerned, dili siya gusto nga i-dispense with ang transcript. So muingon na po sila mag-retake ta. So retake the testimony of the witness. So ibalik na sa namo sa court of origin.
Which will take
Importante
time.
man gud ang transcript kay
Yes.
review ra gud ang amo. May man ang RTC kay diha man sila naka witness man gyud sila pag-testify sa witness pananglitan. Niya naka-take down sila notes. Kami ang amo ra yung
Ang basihan is
basihan
the document.
is the
That's
documents
true.
kay review ra man. So kung walay transcript, di may kahibaw kung unsay testimony sa testigo. Unya ang uban sa giingon na ni Atty. Lucille, wa pay mga ebidensya. Ako kausa naka-remand ko sa record to the court of origin kay wala lagi ang ebidensya, dili kompleto ang record.
So I think this is also a kanang case that we should as lawyers also to IBP to probably raise this matter sa bench and bar na apilon ang mga branch clerks of court. Kay parang di ba kung kita magsitag di ka mo dugay lagi somewhere along the way in the process kay naa may mga kulang, you cannot expect nga mapaspas gyud kay mao na swift and impartial but dili man mas swift kung kung kulang kay it will not move your justice, so you will not consider
In the first
it
place, it will not be justice if it is not swift and impartial. No, di ba? Justice delayed is justice denied. Actually, di ba?
But in this case nga madugay because precisely of the lack of documents, it's really in a way denying the litigants ang what is due them.
Kana sad ba ang mga counsel sa dunta murag kinahanglan magbantay sad kay naman goy uban sa mga abogado nga gamiton ang delaying tactics labi na kung tan-aw nila nga weak gyud ang ilang kaso, napildi sila, ang ilang defense na lang is to delay, no? So mo file sila appeal, perfect nilang appeal, pero dili sila gusto nga paspas ang proseso sa apelasyon kay di sila gusto nga dayon on appeal.
Because the delay mo will be beneficial to them.
So if you are the counsel for the appellee, kinahanglan vigilant ka nga mapaspasan ang kuan ba, see to it that the records. Usahay makasabot man sad ta sa branch clerk of court nganong di magkumpleto kay gipit man sila sa period to remand, to transmit the record to the appellate court. 5 days ago. Di ba, sir?
5 days.
You have only 5
Five.
days to transmit the
Kaso mahitabo
to the,
ang ipada incomplete.
once the appeal is perfected, gamay rang imong time to
So murag para siguro sa ila justice para makas-comply, substantial compliance maski dili kompleto, ilala lang ipada. Unya.
Actually, they can do that provided they have a satisfactory explanation why they are elevating an incomplete record.
So that's acceptable also.
Yes, for as long as they have exerted efforts to complete the record prior to transmitting to the Court of Appeals.
actually nasa lay certification supposed to be nga i-attach sa record, no, nga kompleto ang record, pero
in
kasagaran
some cases,
unsa ilang
they
isulti.
do away with the certificate of correctness. Maybe it's because nga dili man good complete. But then may nalaunta nga kanang at least ilang i-state ang ilang efforts bitaw. So murag dili lang diretso na lang o kuan silent lang sila whether the record is complete or not. So kami na sad ang muukay.
Now, this is not intended to blame anybody, but we're just pointing this out para ma-corrected ang proseso ba. Aron in other words, when we render justice, which is the function of the judiciary, it takes the cooperation of every level involved in the dispensation of justice, from the lowest level to the highest level.
It's kanang teamwork good because that's siguro that's very timely that your statement or your core values were crafted nga kanang kuyog yun
na unity.
Na unity para ang direction ninyo ba kay pwede man kaingon nga paspas ta pero ang uban mo lagi para paspas lang, they will also do kanang not the level of excellence that is required.
So diha sa Court of Appeals, I consider the Court of Appeals to be consisting of four pillars.
Unsa man ni justice?
Of course, the office of the justice or the justices, no, and of course including the staff, no. Second pillar would be the office of the division clerks and the staff, and then the office of the assistant clerk of court and staff, and the judicial record division, because it starts from the receiving section up to the time that it goes to the record goes to the office of the justice for decision making. So it needs really the cooperation and teamwork of each pillar in the court itself.
We're talking about time frame, Justice Attorney Lucille. If all the records are there and then it is endorsed, how long will it take?
Siguro in 2 years time. Okay, 45 days for the submission of the appellant's brief, and then 45 days from receipt of the appellant's brief for the appellant's brief to be filed. After that, the case can be considered submitted for decision already.
They may also file the reply within 20 days from the time the appellant receives the appellee's brief.
So if you have
That's optional.
360 days in 1 year, and you only have siguro 45 plus another 45, 90. Butangan talag allowance nga pag mail,
Mailing and
etc.
receipt.
Another 40 days. That would be 130 days. No? So, that's less than 1 year. Less than 1 year.
But let's remember nga ang atong appellant's brief would come in only kung kompleto na gyud ang record. Usahay good ang madugay diri man sa pag-complete sa record nga kanang mga kulang lagi nga mga documents.
And there are other factors like the mailing.
Kana ang mailing dugay na yun.
ang postal service, no, di ba?
But I think our televiewers have learned na if you just complete your documents or ask your lawyer nga kinanglan imo nang ibusisi, and then all this and with the cooperation of all those involved, you have less than 2 years, and you will have your case resolved before the Court of Appeals. And we will be right back to learn more about the Court of Appeals.
And now we're back. Karon ang storyaan na to is unsa man yung procedures in application for preliminary injunction.
Well, according to the internal rules of the Court of Appeals and also the rules of court itself, no, when there is an application for a preliminary injunction, it has to be served. It has to be heard, as differentiated from an application for a temporary restraining order, which can be issued ex parte. No, now, so mona kinahanglan yung hearing. Now, when we say hearing, that simply means giving both sides the opportunity to be heard. And how may the sides be heard? By giving them the opportunity to submit, or either in writing or orally, what they want to say in order to support their case. No, so usually what happens in the Court of Appeals is we don't conduct a hearing where parties attend and where they orally argue. No, we require them to submit their positions in writing, and after which we consider the incident or the case, the application for preliminary injunction, submitted for resolution. Now, who can issue the writ or can resolve the application for a writ of preliminary injunction or a temporary restraining order? Under our rule, now of course, the division assigned